Welcome to the Supreme Court of the United Kingdom, where today we're embarking on the third day of the hearing in the case of the test claimant in the franked investment income group litigation and HMRC. The case is concerned with a multiplicity of points concerning the taxation of multinational companies and the consequences of inconsistencies between the British tax regime between the 1970s and the 1990s and requirements of EU law. We're currently hearing submissions on behalf of the taxpayer companies presented by Jonathan Bremner, Queen's Counsel. So I'll turn now to Mr. Bremner.
I'm very grateful, my Lord. At the close yesterday, I had started showing the court the revenues suggested conforming interpretation in relation to the issue of reliefs and expenses. That's paragraph 72 in their reply case, electronic page 482. And I'd trailed that this is not an appropriate conforming interpretation. We say that it goes against the grain of the legislation. It fails to give the result required by EU law. There are 4 reasons for that. May I please take them in turn? First, the approach of excluding income from total profits is wrong. What the revenue seek to do is to remove from the total profits an amount equal to the D5 income that should have been covered by DTR. But of course, excluding income from total profits, that is the result of exempting that income from the UK corporation tax charge. And we know, however, from FII CJEU 2 that the dividend income is not exempt. The UK is entitled to tax the income. What should have happened is that additional tax credits should have been given. So the revenues construction is contrary to the fundamental feature that the United Kingdom has an imputation or credit system. The approach is also contrary to the approach adopted by this court in Prudential, and indeed the approach in answering numerous computational issues in this case, which are no longer challenged. So what you would have on the revenues approach is an answer for management expenses, which would then be conceptually different from the conforming interpretation otherwise given to the provisions. And what we see is that that conforming interpretation is offered simply to strand the additional credits that should have been given. That's wrong as a matter of principle. So that's the first reason. The second reason is that the revenues approach fits neither the structure nor the method of the UK provisions themselves. I showed the court yesterday the point that double taxation relief is a relief against the tax that is payable. It's not taken into account in computing the total profit. What, however, you end up with on the revenues approach is a distortion of the calculation of the tax that's due. Because what the revenue does is it works through the steps as normal. So I showed the court these yesterday. Start with the total profits, compute the tax, and then deduct the credit for the DTR. But on the revenues approach, you have to go round the circle again. You have to determine how much of the credit is wasted, use that figure to compute a new figure of profits to gross up the credit, and then deduct that figure from the income. So that's contrary to the approach in the UK provisions. That's the second reason. The third reason is that adjusting, or I would say fiddling with the concept of total profits as the revenue suggests, that would be likely to have serious practical consequences elsewhere in the tax code. Because the concept of total profits is not only used in section 75, it's a fundamental building block of the corporation tax code. Indeed, it goes all the way back to 1965. One can see it in section 53 sub 3 of the Finance Act for 1965. And it's in the tax code in numerous places. It's relevant for capital allowances, ACT utilisation, sideways loss relief and carryback, charges on income. I could go on, but removing the D5 income from the total profits is likely to have lots of other consequences and require significant further amendment to the UK provisions. So the carpentry that's being suggested on the UK provisions, it doesn't make sense. And as we'll see, it's not necessary. So that's the third reason. The fourth reason, and most fundamental of all, is that the revenue's suggested approach doesn't achieve the required objective, which is to prevent the economic double taxation of the dividend. Because in the case of management expenses, the revenue want to say that the management expenses are cancelled because of the lack of a claim for carry forward or the lack of a claim for overpayment relief. And for group relief, the revenue wants to say, well, you can't use the group relief because it's stuck in the company to which it was surrendered and it can't be carried forward. Now, neither of those outcomes in my submission are permissible, because on that approach, what inevitably you would get is the economic double taxation of the dividend income in a subsequent tax year or subsequent tax years as and when profits are made. So in my submission, the revenue's suggested conforming interpretation, which is the foundation for their case on this issue, it doesn't work. Rather, there is a much simpler and more appropriate solution, and that is to apply the requirements in Salonen. Now, what does that involve? Answer: the UK provisions would have to be moulded so that the additional double taxation relief is carried forward automatically and is available for use by the taxpayer in subsequent years. And it would follow, and this is the point we make in paragraph 108 in our case, that where tax has been paid in a subsequent year when DTR should have been available, that tax is unlawfully levied, applying Salonen, and it is paid by mistake. It's recoverable as a San Giorgio claim. When no payment of unlawful tax has yet been made, the DTR would remain available for carry forward. Now that solves the vice in the UK provisions. It doesn't go against the grain of the legislation. It's still treating DTR as credit, as it should. It's a clear and principled answer. And as it happens, that approach, it's also supported by the approach that this court took in the Routier case. The court will recall rejecting an unduly complex conforming interpretation which had been favoured by the Court of Appeal. I don't need to go to it, but just for you a note, in Routier it was paragraphs 50 to 55, and that's Authorities Volume 6, tab 71, electronic pages 5479 to 5480. So I say that to the extent that the UK did not provide for the DTR to be carried forward, and it's common ground that on its face the UK system didn't do this, there is a breach of EU law, and I say that the tax paid in consequence is levied unlawfully and is paid by mistake. Now, Lord, we illustrate how that operates on the ground in our written case with two examples. It's paragraphs 110 to 114, which should start at electronic page 417. This tries to make concrete what I've just been submitting at a conceptual level. And if I can just very briefly illustrate these examples. First of all, example 1. So this is electronic 417. What this does is it illustrates Salonen in a case where there should have been full relief for the underlying tax actually paid. So in this example, we don't actually have to deal with the foreign nominal rate credit. The FNR credit doesn't add anything. What we see is that even in that circumstance, there is a breach of EU law. So we've got company A, it's getting a net dividend of 100. There's 50 of underlying tax that's been paid overseas. Company A has also got management expenses of 15, and we've assumed the UK corporation tax rate is 30%. You've got to work out the D5 income. You do that by grossing up the dividend. So the D5 income is 150. The potential DTR is capped at the UK rate. So the company can't get more than 45. That's 150, and then the 30% applied to it. Section 75 applies automatically, so the total profits become 135. That's your D5 income of 150 less the management expenses of 15. That gives you a corporation tax liability of 40.5. It's met with the DTR. The result, as we say 6 lines down, is that the balance of the DTR, so there's 4.5 of DTR in this example, that's lost. And then, when in a later year, company A becomes taxpaying, what you end up with is the indirect taxation of the year 1 dividend income. Because in year 1 itself, that had been offset by the management expenses. So that's putting some figures on it, which I would hope is of assistance. There's a similar analysis for group relief, and here we give an example on the next page, EF 418 at the bottom. This is example 2, and this also takes in the FNR credit that we now know is required as a result of the Court of Justice's ruling on the second reference. So here, the FNR, you see, is 33, and it's above the UK rate of 30. So we'll come back to the significance of that in a moment. If we leave the FNR out of account to begin with, so that's what we do first, before the application of the FNR, there's 20 under the UK system of available DTR, that's the actual tax paid overseas, foreign underlying tax. The dividend gets grossed up. So there's 120 of D5 income. You take off the management expenses. That gives you your total profit. If group relief had been left out of account, that would generate a corporation tax liability. In this case, it would be 11.5, applying a 30% rate. But group relief is surrendered to offset that. So that works through the numbers. Now what happens when we have to take into account the FNR credit? So there's additional credit that needs to be given. The FNR we saw was 33. That needs to be taken into account in setting the tax credit. It's capped at the UK rate. So the maximum is by reference to a rate of 30%. When you do the maths, that should have given DTR of 36. And so what we see in this example is there is now DTR that's been lost. 16 has been lost. And 20 was used, but the balance wasn't capable of being used because of the earlier application of the group relief and the management expenses. And it's the same result when company B and company C, when they become tax-paying in the later year, there is then indirect taxation of the dividend income in that later year. And I rely on Salonen for my submission that breaches EU law. Now, of course, Salonen was not directly concerned with foreign nominal rate credits, but, and this is common ground, there's no difference of principle. What's going on here is that EU law is seeking to ensure equivalent treatment of domestic source income on the one hand and overseas source income on the other. And the function of the FNR credit is to ensure that equivalent treatment. And so the principle in Salonen that the national law needs to ensure that DTR can be used, that applies just as much to the FNR credit as it does to the credit for tax paid. And that's the point we make in our case at paragraph 112. May I please make two further points on group relief? First of all, it makes no difference to...
I'm sorry, Mr. Bremner, you broke up there.
Sorry. Oh, I'm very sorry, my lord. I was saying I'd like two further points, if I may, on group relief.
No, I'm afraid we're not able to make out what you're saying at the moment. There's obviously some electronic gremlin. I wonder if our IT engineer is able to...
I'm very sorry, I can hear you.
No. I think our IT engineer is going to have to try to give you some assistance with this. Shall we adjourn for a few minutes? I mean, we'll come back on as soon as the problem's been addressed. It may just be a matter of logging out and logging in again. I'm not sure, but we'll mute ourselves and stop our video feed in the meantime while it gets sorted out. Well, I think we've now sorted out the problem and we're able to resume. Mr. Bramley.
I'm very grateful, my lord. I was just about to make two further points on group relief. First of all, it makes no difference to the analysis that the unlawful charge is borne by a different company from that which received the overseas dividend income. Because what group relief did was, through the surrender and claim mechanism, that allowed losses to be transferred within the group. And it meant that the tax charge was postponed to a later period and transferred to a different tax-paying company within the group. And as we note at paragraph 116 in our case, that's exactly the same as a matter of principle as the situation with group income elections. And we know from FII ECJ2 that in that situation, a San Giorgio claim arises. That's in FII ECJ2, paras 66, 71 to 74, 75 to 82, and 83 to 87. It's electronic pages 1656 to 1658. And so just like the group income election, the use of group relief postponed the charge, it transferred the tax liability, so the company that paid the tax has a San Giorgio claim. Secondly, it is not an answer, contrary to paragraph 87 in HMRC's reply case, to say that if company A mistakenly surrendered too much group relief to company B in a domestic situation, then the group relief could not be carried forward. That doesn't work because the revenue is not here comparing like with like. Domestic dividend income was exempt, so utilization of relief simply did not arise. And what is happening here is that on the revenues approach, the additional tax charge created by the UK provisions goes unrelieved. And we know from Salonen that that indirect taxation of the dividend income is unlawful. So the revenues approach is failing to restore the necessary equivalent treatment, and it is not eliminating the extra tax charge, which on a domestic situation would not have arisen. So, Lord, in my submission, Salonen compels the conclusion that the DTR has to be carried forward. Just for completeness, I should deal with an alternative potential analysis. That's to say that the use of the release was a nullity and never happened. As your Lordship will recall that in Prudential, it was held that the unlawful tax charges, the unlawful ACT and unlawful MCT, that they were nullities. And that's the point I'll come back to in that particular context. It might be tempting to see the use of release in the same way, but I don't urge a nullity analysis on the court in the context of the claim for relief. The reason for that is that we know in FII ECJ2 that there's nothing unlawful in taxing the overseas dividend income provided adequate credit is given. So the unlawfulness arises because the credit wasn't adequate. So while mathematically you might get to the same place if you carried forward the management expenses or restored and carried forward the group relief, in my submission conceptually that wouldn't be the right approach. But if that was the line that one were to go down and the court were attracted by a nullity analysis in this context, you would get to the same answer, because you would still need to respect the point that the member state must prevent the indirect economic double taxation of the dividend in a subsequent year. So if the use of the relief is ineffective, they would still have to be available for use to prevent that indirect economic double taxation. So that's the claimant's primary case on issue 11 and 13 CA1. Our alternative case proceeds on the basis that for some reason Santmanen doesn't provide the answer or doesn't provide a complete answer. Now, in my submission, given that it appears that Santmanen analysis is common ground and that the UK provisions on the use of reliefs were incompatible, and the only point that's live seems to be the conforming interpretation issue, our alternative case may not arise. But I do still rely on it, and so I adopt paragraphs 120 to 133 in our case, and I make two submissions. First of all, I say that the claims in respect to the management expenses and group relief, they're properly to be seen as San Giorgio claims, and whether or not that is right, I say secondly that they are properly to be characterised as claims in unjust enrichment in domestic law. First of all, on the EU question, whether the claims are San Giorgio claims, we say that applying the guidance in ECJ1, these claims are indeed San Giorgio claims. But that guidance is at electronic page 1540 at the start of it of ECJ1, and the relevant passage is at 1570. It's paragraphs 205 to 207. And we looked at this with Mr. Ewart on Monday. And paragraph 205 is the express recognition that the taxpayer is entitled not only to reimbursement of the tax unduly levied, but also the amounts paid to the state or retained by it, which relate directly to that tax. And in parentheses for now, but we'll come back to this, that also includes time value. 206 was directed at surplus ACT. Mr. Justice Henderson explained that in FII High Court 1, para 232. Para 207, the ECJ held in terms that this did not include waivers of relief, and it didn't include damage suffered as a result of increasing dividends. And the court said, if one goes just below the letter D, that those waivers and the increases in the dividend, they were the results of decisions taken by the companies and weren't an inevitable consequence of the failure to grant equivalent treatment. Now, if one looks back at the questions, and this is question 6, which you get at EF 1547, this is paragraph 30, within paragraph 31 in the judgment. Question 6 splits out a series of different types of claim, 9 in total. And the two that are ruled on in paragraph 207, they are Roman 5, that's disclaiming the other relief. That's where the language of waiver comes from, by the letter D. And Roman 9, just above the letter F, that's the enhancement of dividends. The other claims weren't dealt with specifically by the Court of Justice. They were left to the National Court, and the Court certainly did not say that those claims were not capable in principle of constituting San Giorgio claims. So what we need to do is apply the Court's guidance, and particularly paragraph 205, to these claims. Now, on this, in relation to management expenses, I showed the court yesterday that the set-off of management expenses was automatic under the UK tax regime. And given the automatic nature of that set-off, losses suffered as a result of setting off the management expenses necessarily flowed directly from the breach of EU law. They are recoverable as San Giorgio claims. And the Court of Appeal, in Court of Appeal 1, it was plainly wrong when it said, and this is paragraph 149 of its judgment, it's at electronic page 787 if you want to see it, when it said that the use of management expenses was the result of tax planning and commercial decisions that were entirely within the discretion of the claimant. You see that in the penultimate sentence in paragraph 149. Management expenses said to be the result of tax planning and commercial decisions. No, that's obviously wrong. There was no discretion about it. The application of the management expenses was the automatic result of section 75(1). And all that it did was postpone the unlawful tax charge to a later period. Group relief in my submission has a similar analysis. Set off of group relief was routine under the group taxation regime that was enforced throughout this period. Indeed, the system was designed on the basis that the group would make use of the losses available to reduce its overall tax liability. And indeed, if you look at the ruling out of the waiver of relief claims, what broke the link was the decision not to use the relief. And so I say that in a routine context, paragraph 205 applies. What we're looking at is whether there are amounts paid to the state or retained by it, which relate directly to the unlawful tax. That's paragraph 205. And standing back from this, if a relief is used against an unlawful tax charge, all that is going to happen is that the unlawful charge is postponed to a later point in time. And that clearly, in my submission, relates directly to the unlawful tax. It's an inevitable consequence of the unlawful tax. All that has happened is that the use of the relief has postponed the making of taxable profits and the payment of the unlawful liability to a later point in time. It is absolutely true that the waiver of capital allowances and the SID enhancement cases that are dealt with in paragraph 207 by the Court of Justice, they're in a different category. That's right. But it doesn't alter the point of principle. That's the San Giorgio point. Finally, on this, on domestic law, I can take this short, and I adopt paragraphs 134 to 136 in our case. I say that it is clear that the relief had a value. If one looks at this as a matter of principle, the tax system involves an ongoing account as between the taxpayer and the revenue. So on any occasion where a taxpayer uses a relief or an allowance, he's giving up something of value. It's a tax asset, it's a credit that can be used to reduce the taxable profit and therefore to reduce a tax liability. And equally, the revenue gets something of value when the taxpayer uses those reliefs, because the consequence of the reliefs being used is that the revenue will receive more in tax when the claimant next makes profit. And that's precisely because after the relief has been used, it can't be used again. And you can conceptualize this in one of two ways, as we say in paragraph 135 in our case. You can see it either as restitution of unlawful tax paid in year 2, or you can say it's the charging of unlawful tax in year 1 against which reliefs are applied, and then you know what the value of the enrichment is after the company next becomes tax paying. Now, if all of that's wrong and there's no enrichment, in my submission, that can only be on the footing that the reliefs have not been expended and they remain available for the claimant to use. Now, I'll just deal briefly, if I may, with the Revenue's 3 objections in their case in reply. First of all, they say, this is their reply case, para 98, that the money payment in year 2 was lawfully due. That's wrong. We know that EU law doesn't permit the indirect economic double taxation of the dividend, but that's exactly what's happening on the Revenue's case. So it's just not right to say that the year 2 charge is lawfully due. Secondly, it said there's no direct transfer from the claimants to the defendants. That's the reply case, paragraph 99. That's wrong as well. If the relief was wrongly expended in year 1, the natural consequence is there's too much tax to pay in year 2. The two events are linked. And there's no analogy with this court's ruling in Prudential on issue 3, the lawful ACT utilised against unlawful mainstream corporation tax. Because what was critical there is that the ACT in that case remained available for use by the taxpayer. That was paragraph 101 in this court's judgment. That's not the position here. On the revenues approach, the release would no longer be available for use. And certainly, as far as management expenses are concerned, if the release did remain available for use, it was applied automatically in year 2. So there would have been an overpayment of tax by mistake in year 2 on any view. And the third objection, this is the revenues case in reply to paragraph 100, is it said, well, we don't identify the enrichment of the revenue. I don't accept that. In my submission, when the relief is used, there is a benefit to the revenue. The relief is no longer available to be used against a liability which would otherwise be owing. And so there is, in my submission, a close analogy with the situation of a debt being forgiven. The revenue is in the circumstance of a creditor who has a running account. It's received a credit, and that reduces the debtor's overall liability. Now, we may not know exactly how valuable that right is until year 2 when the tax is paid, but all that would involve is the revenue receiving a benefit in year 1, the value of which then becomes clear in year 2. That's the first series of points made by the revenue. I'll just conclude on group relief, and this is responding to their paragraph 103. There, the point made against me is to say the revenue weren't enriched by the mere surrender, and they also repeat the point on tax lawfully due. Neither point helps them. First of all, you can't simply look at the surrender. The group relief legislation contemplates one operation. We saw that yesterday, section 402 sub 1. It's a surrender by the surrendering company and a claim by the claimant company. It's artificial to see this as a two-stage process. The only reason there's a surrender of group relief is precisely so the claimant company can set the amount off against its profits. And the second point, and I've made this point already, is that all that group relief is doing is postponing the tax liability and changing the tax-paying company. And we know from the treatment of the corporate tree defences by the ECJ on the second reference that neither of those aspects bars a restitutionary claim. And so the revenue is wrong to say that the year 2 tax payment is lawfully due. All that's happened is that the unlawful tax liability has been postponed to a later year, and that a different company in the group has paid that tax liability. So in my submission, the claimants succeed on issue 11 and 13, either applying Salonen or alternatively on the basis of our alternative case. In other words, those are my submissions on issue 11 and 13 from the First Court of Appeal. I now turn to issue 26A and issue 10 from the Second Court of Appeal judgment. That's the Sempra issue, and I adopt paragraphs 137 to 212 of our case. For my oral submission, it will be most efficient for me first to deal with the substantive points and then to turn to the questions of res judicata. On the substantive issues, I'm going to develop my submissions in 3 stages. First, I'll address you on what this court decided in Prudential, and in my submission, it recognized that the claimants have a domestic law claim even where ACT was utilized, and it follows from Prudential that that claim is restitutionary in nature. Secondly, I will show you why that ruling was right and indeed required by EU law. And thirdly, I will submit that there is no difficulty in giving effect to the right to interest which derives from the claimant's restitutionary claim. There are a number of options, each with materially the same outcome. My preferred analysis, and I'll explain why, is that the claimants have a mistake-based restitutionary claim to which Section 35A, Senior Courts Act 1981, is then applied. So, Lloyd, if I can start with my first topic on what Prudential decided, I'd say that this court has made clear that there is a claim in domestic law for the time value of utilised ACT. And that is so regardless of Section 85 and 86 Finance Act 2019, on which the Revenue placed so much emphasis in their opening. I'll show you Prudential, but just to flag where I'm going, there are 2 points in particular that I will draw from this court's judgment. First of all, Prudential expressly recognised that the claimants were entitled to an award of interest in domestic law for the time value of the utilised ACT, and we'll see that in paragraph 78 and again in 110. And that both fits with and is required by the San Giorgio principle and the claimant's EU law rights. And what we'll see is that all that's needed to give effect to those rights is a purposive interpretation, is necessary a conforming interpretation of Section 35A. And what we'll see is that that is straightforward. That's the first aspect of Prudential. The second aspect is that Prudential recognises that unlawful ACT charges and unlawful MCT charges are nullities. And I'll show you paragraphs 101, 110, and 120. And that'll be important because the recognition of an unlawful ACT charge as being a nullity would, in my submission, if the court's not with me on my primary case on Section 35 capital A, give an alternative route for the necessary interest award to be made. So can I show you Prudential? It's Authorities, Volume 2, tab 14. And if I can pick it up, please, it's electronic page 3535. These are the categories of claim with which the court was dealing. And at this point in the litigation, all 3 categories are being pursued on the basis of unjust enrichment, compound interest being sought on all 3 categories. With category A, the unlawfully levied ACT subsequently set off against lawfully levied MCT, and then the timing, this is the so-called SEMPRA period from the date of payment to the date of set-off. Category B, we've got the other unlawfully levied tax payments, so that's the unlawful MCT, the surplus ACT, etc. And then category C is the time value of the utilised ACT. So that's interest on the amount that is produced by the category A claims. So those are the 3 categories. And in relation to all 3, and this is a very important background point that I'll come back to, each claim depends on the tax in question, and here we're concerned with ACT, being held to be unlawfully exacted for the purposes of the Woolwich cause of action, or mistakenly paid for the mistake cause of action. Now, I'll take short how the court went on to deal with the issue. So we didn't go through this in detail in opening, but I've no doubt the court is familiar with it, and will recall that in Prudential, the court examined in detail the reasoning in SEMPRA, set out paragraphs 42 to 54, and then it looked at legal development since SEMPRA, so that's paragraph 55 through to 67, and in particular, the development in the Court of Justice's own case law since Metal Gesellschaft and the question of interest. That was noted in paragraphs 55 and 56. And that's the point I'll come back to. Then the basis of the ruling in Prudential on issue 2, it stemmed from the at the expense of requirement or element when it comes to a common law unjust enrichment claim. And that discussion starts at paragraph 68. One sees the purpose of the unjust enrichment claim to correct normatively defective transfers of value. That's an echo of the point in the investment trust case, which Mr. Anderson referred to yesterday. Then paragraph 71, electronic page 3546, final sentence, the opportunity to use the money, that's not a distinct and additional transfer of value. And then the court gave a further example in paragraph 72. And you'll recall the transfer of value being reversed, payment of the £1,000. There's no restitutionary right to interest on the £1,000 in and of itself. But as the court notes in that example, the claimant can be awarded interest on the £1,000 under section 35A. And the reason for that, as the court says, is that the obligation which arose under the law of unjust enrichment, that created a debt, and interest can normally be awarded on a debt under section 35A. That's the final sentence of paragraph 72. So the right to interest under section 35A, that's parasitic on the unjust enrichment claim. Section 35A is not a freestanding cause of action. What the court then does in paragraph 77, electronic page 3547, is to hold in terms that interest can be awarded under section 35A on both the category A claims and also the category C claims. And that is said to be a conclusion that inevitably follows from the court's analysis. And looking back at paragraph 34 on page 3535, that's an interest award under section 35A in respect of both the claims for unlawfully levied tax, that was category B, and also the amount that resulted from the category A claims, that's category C. And that recognition that section 35A interest can be awarded on the category C claims, that's critical because it makes clear that there must be a domestic claim for category A in the first place. Because conceptually, there couldn't have been any category C interest absent a successful claim for the category A amount. So that takes me directly to the category A amount, and that's dealt with by the court at paragraph 78. And we looked at this with Mr. Hewitt on Monday. The court notes that on a literal reading of section 35A, no such interest, that 35A interest, could have been awarded on the category A claim. And that's because the debt had been repaid as set off before the commencement of proceedings. Now, there's an assumption there. Has there really been a set-off? And I'll come back to that. But regardless of whether literally section 35A could apply, what's critical is the recognition by the court that an awarded interest is nevertheless required in such circumstances by EU law if an effective restitutionary remedy is to be available under English law in respect of San Giorgio claims. That's under reference to metal dispulsion. And the court, as it goes on to say it, didn't need to determine in that case how the award of interest should be made available. But it said there were a number of potential solutions. So I draw 3 points from paragraph 78. First, there must be an award of interest in respect of the category A claims. Secondly, the court expressly recognises that that award is being made so that an effective restitutionary remedy is to be available under English law in respect of San Giorgio claims. And thirdly, the court's reasoning has nothing whatever to do with section 85 and 86 of Finance Act 2019. Those provisions didn't exist at the time. They hadn't even been announced that they would be enacted. They are irrelevant to this court's analysis in Prudential. And what we'll see, notwithstanding the revenue's objections, is that there is no difficulty in giving that effective restitutionary remedy in this case. And that has to be the correct result, not least because it's the only way for English law properly to give effect to the claimant's San Giorgio's repayment right. Now, before I develop those submissions, I need briefly to deal with the court's further discussion of utilisation. This is in the context of issue 3 and issue 5. Now, on issue 3, this starts at paragraph 87. This is electronic page 3549. Paragraph 87 clarifies terminology. So the court tells us what it means by lawfully, from C first of all, just under the letter E. and also unlawful MCT, that's between S and G. There's no express definition of unlawful ACT in judgment, but in context, when the court is talking of unlawful ACT, it must be understood in a similar way to how the court characterizes unlawful mainstream corporation tax. So it's the part of the ACT charge that's attributable to the failure to give the necessary credit under section 231. That's the terminology. Over the page, 3550, paragraph 90 sets out section 239, making provision for the set-up of ACT against the MCT charge. I don't need the detail on carry back in para 91 and carry forward para 92, or the detail on the way the set-up operates in para 93. It's worth just noting the revenue submission, which is the submission on issue 3 that was accepted. That introduces the notion of unlawful MCT as a nullity, and of the set-up in section 239 as not operating in relation to a nullity. I don't need to trouble you with the submissions, which is I made for Prudential in paragraph 95. I can pick it up with this court analysis, that's paragraph 96, which I don't need, that's just the procedure. Paragraph 97, this is electronic page 3552. That is important, and because it introduces what is described as the logically prior question of whether there's been any set-off under section 239. And what we then see, if you go down to the bottom of 3552, paragraph 101, the revenue submission on nullity is accepted. We see that if an apparent charge to MCT is unlawful, that charge is a nullity. And we also see that the ACT, in the second sentence, couldn't have been set against a nullity. Instead, it remained available to be dealt with under section 239. And that's what founds the court's conclusion that the lawful ACT didn't relate directly to the unlawful MCT. And that was why the claim for restitution in respect of lawful ACT utilized against unlawful MCT failed. Para 104, we see that. That's issue 3. On issue 5, I just need to make 2 short points. First of all, in issue 5A, which on electronic page 3553, you see set out at paragraph 106. So we're looking at the utilization of ACT for the purposes of computing the claim. And the court dealt with that question in the following way. First of all, paragraph 107 set out the competing provisions. And importantly, in the final sentence of para 107, 4 lines from the bottom, this is just by the letter B on 3554, insofar as unlawful ACT has purportedly been utilized against unlawful MCT, the unlawful ACT is recoverable with section 35A, because that reflected the ruling on issue 2. Paragraph 108 and 109, they note the judgment below. I don't need to go into the detail of that, but para 109, that set out the pro rata approach, which had been taken by the Court of Appeal in Prudential, and that emphasises with common ground the point that a payment of ACT represented an undifferentiated fund. You see that just below, between the letter E and the letter S on page 3554. The bit I need is paragraph 110, which is important. Can I just work through that briefly at the bottom of 3554? What we see in 110 is, first of all, that under section 239, lawful ACT is not set against unlawful MCT, which is a nullity. And that meant that the revenues pro rata method couldn't work. Instead, the lawful ACT remained available to be dealt with under section 239. And you see at the top of 3555 that the unlawful ACT that also wasn't set against the unlawful MCT charge. And you see just below the letter A, that was because both the unlawful ACT charge and the unlawful MCT charge are nullities. That generated the principled answer that the court came to, and we'll come back to this under issue 11 at the end, but I don't need so much of this just now. But the principled answer was that unlawful ACT was to be treated as having first been utilised against the unlawful MCT charge. And then we see just above the letter B, where there's no unlawful MCT against which to set the unlawful ACT, the residual unlawful ACT, so what's left of the ACT, that's to be treated as, and I emphasize the word treated as, utilised against lawful MCT. As the court emphasised, both of the unlawful charges are nullities. And what that meant was that the unlawful ACT was itself recoverable, and that was so unless it had been set against a lawful ACT charge. And then lastly in this paragraph, but critically, in the final sentence of paragraph 110, the court recognised expressly that when unlawful ACT has been set against lawful MCT, Company A, so that's the company that paid the ACT, it has a claim for interest on the ACT so used, as stated in paragraph 78 above. So in that final sentence of paragraph 110, this court was reaffirming its earlier conclusion of paragraph 78 that there's a claim for interest on utilised ACT. And that claim, as we saw when we looked at paragraph 78, is an integral part of providing the effective restitutionary remedy that EU law demands. And so the revenue is simply wrong to suggest, as it does in its case in reply, that the claim may only stand in damage. That submission flies in the face of Prudential paragraph 78. Lastly, on issue 5, when it came to issue 5B, this is a particular point about the carryback of franked investment income. You see it introduced at paragraph 112, page 3555. If one looks at paragraph 120 on page 3557, the conclusion that unlawful ACT is a nullity, that was the very basis for this court resolving issue 5B in Prudential's favour. So in my submission, Prudential is clear that there is a domestic law claim for interest on deemed utilised ACT, and that claim is part of providing the effective restitutionary remedy that EU law demands. And that ruling is entirely correct. And I'm moving here on to topic 2. It's correct, first of all, because that's what EU law requires. Secondly, it's right conceptually. And thirdly, it's right because it fits the facts of the ACT claims. Can I deal with those aspects, please, in turn? First, in relation to what EU law requires, we know that the restitution that is required by EU law includes interest, including interest for the period of prematurity, or the SEMPRA period, as it's being called in this hearing. We've given the references to the main cases on this in paragraphs 190 to 196 in our case. That's electronic pages 443 to 444, and set out the main extract. That's Herx. The Court of Justice's ruling on the first reference in this case, FII CJEU1, and Littlewood CJEU. And I'm not going to take you back through that material unless you particularly would like to see it. I should just add to that this court's ruling in Littlewood's Supreme Court, where having reviewed the CJEU authorities, this court expressly held and recognise that there's a general entitlement to interest on tax levied in breach of EU law. That's paragraph 52. And there are also passages to the same effect at paragraphs 59 and 67, and the electronic pages for that are 5146, 5148, and 5149. And the right to interest runs, as the court observes in Littlewood, paragraph 67, page 5149, in paragraph 6. Sorry, I've given myself a bad reference. Paragraph 67. Yeah, sorry, 5151, and it is paragraph 67, but it's page 5151. The right to interest running from the date of payment to the date of repayment. And all of those authorities validate the observation that this court made in Prudential at paragraph 78, that the award of interest is required by EU law if an effective restitutionary remedy is to be available under English law in respect of San Giorgio claims. So the starting point for this is that the claimant's entitlement to restitution includes a right to interest on that tax. That's the first point. Second point is that the court in Prudential was right conceptually, because when the claimants paid the unlawful ACT, they had a claim in restitution which arose on the date of payment. And it's vital to bear in mind in this context that the proceedings for the ACT claims, they had to be brought in order to demonstrate that the ACT was unlawfully levied. Indeed, as we'll see, it's only as a result of the rulings in this litigation that we can even calculate what ACT was utilised and when. And the entitlement in relation to these claims included an entitlement to interest. So it's that entitlement, including the entitlement to interest, that the claimant sought to vindicate through their willage and through their mistake-based claims. And there can't, in my submission, be any question in those circumstances of the unlawful ACT claims somehow being extinguished or cancelled when there was a purported set-off under Section 239. We only know that there was unlawful ACT because of these proceedings, and we only know when ACT is to be treated as utilised because of these proceedings. And so the claims necessarily still existed when the proceedings were instituted. The entitlement to interest is an EU law right, which is being given effect through these claims. And secondly, and critically, the whole notion in this context of unlawful ACT being utilised against lawful MCT is, in my submission, a computational analysis which is taking place after the institution of the proceedings for the purposes of valuing the claims. And it is simply not possible, consistently with EU law, for the claimant's claims for unlawful ACT to be extinguished upon a purported set-off. The third point is that certainly in the case of BAT, the court's analysis and Prudential, it fits the fact, and the revenues approach in this hearing doesn't. And the reason for that is that in the case of BAT was never actually able fully to use up all of its ACT in any one year. There ended up being an ACT mountain, it was called in SII High Court 1, which built up and built up over time. And I'll show you that in a little more detail, but the point of principle is that it can't be said prior to the proceedings being issued that any particular part of the debt owed to BAT had been repaid. So in my submission, the position is this. On the day that the unlawful ACT was paid over to the revenue, the claimants had a restitution claim for its return and an EU law entitlement to interest. And it cannot be right in my submission that part of that claim was simply extinguished. Where the limitation period hasn't expired, that would breach the principle of effectiveness. Indeed, it would contradict the policy of the Limitation Act to protect claims in mistake from expiring before the mistake could have been discovered. And that isn't what happens. The claim isn't extinguished because we know from Prudential that the claimants do retain the right to bring a claim so as to be able to secure an award of interest. And that's an English domestic law right. It has to be, because it's the domestic remedies that give effect to the claimant's EU law right. And so in my submission, the claimants have their national law remedies in Woolwich and in the state, and they always have those remedies right up until judgment. So where we are is that the claimants brought claims in Woolwich and in the state within the time period. As part of those proceedings, it was established that the ACT paid was unlawful, and Prudential makes clear that for all categories of claims, there has to be a right to interest in relation to the debt that was created by the payment of the ACT. And it's not a permissible conclusion that the claim is simply cancelled in part. That would breach the requirements of effectiveness, because there then wouldn't be a claim enabling the necessary award of interest to be made. And it would also mean that the claim would have disappeared at some indeterminate time, and notwithstanding that proceedings for the recovery of the ACT had, ex apocrypha, been commenced within the limitation period. So I say that the payment by mistake of the unlawfully levied ACT, that gave rise to a debt and a restitutionary claim for its recovery. The claimant's entitlement included an entitlement to interest, and the entitlement to interest derives from the original overpayment by mistake of the unlawfully levied ACT, and there can't be any question of that claim having been extinguished. And once it's accepted that there was a claim in existence at the commencement of proceedings, as we'll see, there is no difficulty in giving effect to it through Section 35A. Now, before I look at Section 35A and also at the potential alternative route, I would just like to develop what I said about the facts of BAT's case in just a little bit more detail. Because when we look at the facts of BAT's case, we know from Prudential that ACT was an undifferentiated fund. So the payments of ACT, they comprise both lawful ACT and unlawful ACT. In just the same way, payments of mainstream corporation tax comprise both lawful MCT and unlawful MCT. Now, in the case of British American Tobacco, and this becomes very clear from FII High Court 1, BAT was never able fully to utilise ACT in the year that it was paid. And this came out of the evidence of Mr. Hardman from its tax department. This is in FII High Court 1. It's electronic page 1005, Court Volume 2, tab 13. And this is Mr. Justice Henderson, who quotes Mr. Hardman's witness statement. And all I need is the paragraph over the page, on page 1006, paragraph 16, where Mr. Hardman makes clear that BAT has never been able fully to utilise ACT in the year it was paid, and he explains how it then developed. So the brought forward surplus ACT, it then peaked at £460 million by 1992. And that evidence was then reflected in the findings that were made at paragraph 33 in FII High Court 1. And so you see 4 lines down, first of all, is reference to a schedule illustrating the build-up of ACT, and then 10 or 11 lines down, halfway through the paragraph, if your lordships have a sentence starting, the result was that ACT took longer and longer to utilise. Could I just invite you, please, to read from there to the end of paragraph 33 in FII High Court 1, please? you have the picture of it becoming more and more difficult to utilise the ACT, and then by 1987, ACT becoming permanently surplus. And I say in those circumstances, it can't be said prior to the bringing of these proceedings that any particular payment of unlawful ACT has been set off against lawful mainstream corporation tax. The question of how to deal with utilised ACT or purportedly utilised ACT in my submission, it can only be approached as an after-the-event process of analysis that's undertaken for the purposes of valuing the claim. And that indeed is exactly the sort of analysis that's described by this court in Prudential at paragraph 110. The process that is set out in that paragraph, it's something that's being done in response to this very claim. And indeed, electronic page 3555, you'll recall the language, important language in Prudential paragraph 110, that the residual unlawful ACT is to be treated as utilised against lawful MCT, that's the letter B. And of course, the claimants have only been able to establish that there even was a debt through the bringing of these claims in the first place. And so in my submission, if we're looking at the original payments of ACT, it cannot be said in this case that prior to the issuing of the proceedings, any particular debt or part of the debt was repaid or set off. The ACT lay in an undifferentiated pool, and the analysis that has to be deployed for the purposes of valuing the claim has only been determined in the course of this litigation, so necessarily after the proceedings have been issued. And in fact and in law, the payments of tax, they were nullities. They were not in fact set off, they were treated as having been set off as part of that valuation methodology. Now, I was turning to my third topic. In my submission, there is no difficulty in giving effect to the claimant's entitlement to interest. My preferred route is section 35 capital A subsection 1 of the Senior Courts Act 1981. There are alternative routes, but in my submission, I don't need them, but I will just mention them briefly so you have my position on them. Before I look at the available routes, I should say that I'm going to deal at the end with section 85 and section 86 of Finance Act 2019 and the reliance that Mr. Ewart has placed upon them in opening. But in my submission, section 85 and 86, they are irrelevant to this case. Prudential recognised the claim to interest on the 25th of July 2018 before section 85 and 86 had even been announced, let alone enacted. And so what this court was doing in Prudential was recognising a claim that existed in domestic law without regard to section 85. And as we saw with Mr. Ewart in opening, section 86(2) provides in terms that the section 85 remedy is not exclusive. So the remedy that this court recognised in Prudential, it continues to exist. And section 85 simply gives an additional remedy, and as it happens, it doesn't even apply to the claims relating to set-off of ACT or purported set-off of ACT, which preceded 1996. And so section 85, it cannot, as a matter of principle, as we'll see, give an effective remedy for those pre-96 period. It also can't take away rights with retroactive effect. I wonder if that might be a convenient moment before I embark on the detail of this. I'm very sorry, I can't hear Lord Reed.
Oh, but we would adjourn for 5 minutes, Mr. Bremner.
I'm very grateful, my Lord.
We're now ready to resume the hearing. Mr. Bremner.
I'm grateful, my Lord. I was just about to embark on section 35A and giving effect to the right that I have been identifying before the break. In my submission, there's no difficulty in giving Section 35 capital A a purposive interpretation or a conforming interpretation which enables an award of interest to be made in respect of the claimant's restitutionary claims. And that's particularly so when one considers both the nature of the EU law right in this case and also the nature of the claims. And I'll just deal with that briefly before I get to Section 35A itself. The nature of the EU law right, first of all, your lordships have my submission. National law must give a San Giorgio remedy for interest. That's clear from this court's judgment in Littlewood Supreme Court. And that remedy derives from the original mistaken payment of the unduly levied ACT. You also have my submission that the restitutionary claim arose upon the payment of the unlawful ACT by mistake, and that the claim cannot have been extinguished prior to the issuing of the proceeding. And I'd say against that background, and particularly given that we know that EU law requires there to be a remedy for the SEMPRA period, the approach to the construction of Section 35 capital A is straightforward. First of all, the claims are founded on mistake of law and on willage. The claimants only have a repayment right because there was ACT unduly levied and paid by mistake. So necessarily, that's the foundation for the claims. Section 35A is not a freestanding cause of action for interest. It's triggered when there are proceedings for a debt. And we know from the Court of Justice's judgment in Metal-Gesellschaft that it was not permissible for the revenue to rely on a rule of national law according to which the court has no power to award interest in respect of debts paid late but before proceedings were issued. There was a procedural bar, but that bar has fallen, and I should show you the relevant passages in Metal-Gesellschaft that illustrate that. That's Authorities Volume 2, Tab 20, and I can pick it up most easily in the opinion of the Advocate General, which is at electronic page 3785, although the passage that I would ask you to look at is at 3786. This is Advocate General Kennedy, and he's pointing out a number of matters of common ground in paragraph 12. You see that by the letter H at the bottom of 3785. And the important point for my purposes is on 3786, just below the letter B, at number 0.5. Because what the Advocate General is doing is noting that it's been said that under the law of the United Kingdom, there would have been no right to the repayment of such advanced corporation tax, even if the action had been successful. Because, of course, in Metal-Gesellschaft, because of the absence of the group income election, all of the ACT paid, because no group income election had been made, had ultimately been set out against lawful MCT. What's important for my purposes is the description in the round bracket starting just above the letter C. And this is where more explanation is given of what was actually being put before the Court of Justice in this case, because there's reference to the written observations of Metal-Gesellschaft and the other claimants. And so the Advocate General explains, we're looking at Pintada. The rule dates back at least to London, Chatham and Dover Railway. And what we're looking at is a rule that in the absence of any agreement or statutory provisions for the payment of interest, a court had no power to award interest, simple or compound, by way of damages for the detention, i.e. the late payment of a debt. And then later, critically between D and E, Lord Brandon expressing approval for the view that the rule now only applies to claims for interest in respect of debts paid late, but before any legal proceedings for their recovery have been brought. And that view in itself was under challenge, but as you see from the Advocate General, he's going to assume that rule applies. And that was a matter that was covered by the questions that were being put to the court. And you see that if you look at question 2 in the reference in paragraph 13, lower down the page by the letter G, looking at whether there's a restitutionary right, or whether it can be claimed, if at all, by way of an action for damages. And then critically, the last two lines of page 3786, asking whether in either case is the National Court obliged to grant a remedy, even if under national law interest cannot be awarded, whether directly or by way of restitution or damages, on principal sums which are no longer owing to the claimants. So that was the more detailed description from the Advocate General. There was a shorter description from the court, which one can see in paragraph 79, which the court goes on to electronic page 3820, letter G to H. This is recording the UK's submission, particularly its final sentence, that entitlement to interest depends on whether proceedings were commenced prior to payment. So there's an echo there of what the Advocate General has been saying in his paragraph 12. And the court's conclusion is simply that that rule cannot be applied. That's paragraph 88 in the context of the restitution claim to 89. And then paragraph 93 for the damages claim. And that's reflected then in the answer that the court gives, on page 3823, the answer to paragraph 96. So the court says in terms between the letters F and G that the mere fact that the sole object of such an action is the payment of interest equivalent to financial loss suffered as a result of the loss of use of funds paid prematurely doesn't constitute a ground for dismissing such an action. And so where we are is that the rule that no interest can be awarded in those circumstances simply cannot be applied. So the procedural bar that might otherwise have operated simply cannot be relied upon. The other relevant point, and I've made this already, is that when the claim was first brought in 2003, it was impossible to know what ACT had been set up against what MCT. And one of the very issues in this litigation has involved determining the correct methodology for answering that question. That's largely covered by issue 11, Court of Appeal 2 in this case, an issue largely resolved by this court's ruling on issue 5A in Prudential, but of course there's the remaining aspects of issue 11 CA2 on surrender that I'll come to later today. So in those circumstances, and having regard to this court's ruling in Prudential, paragraphs 78 and 110, that there must be an award of interest, the conclusion should be that this claim constitutes proceedings for a debt within the meaning of section 35A, and that the court is able to award interest on the category A amount under section 35A in response to those proceedings. And there is no difficulty in my submission in interpreting section 35 capital A to give that result. Section 35 capital A is in volume 1 of the authority. It's divided 6. And this is electronic page 3230. All we need is proceedings for the recovery of a debt to get within section 35 capital A1. And I say that's exactly what we have in this case. We have the mistake claims and the willage claims in respect of the original overpayment of ACT. Simple interest, reading on, can be awarded not only on all or any part of the debt in respect of which judgment is given, but it can also be awarded on all or any part of the debt in respect of which payment is made before judgment. And that award can be made, as we see from 35 capital A, subsection 1, subsection A, for all or any part of the period between the date when the cause of action arose and the date of the payment. So there's no difficulty in terms of section 35A. What my learned friend has to say is that the cause of action for utilised ACT was extinguished before the proceedings were issued. That doesn't work. First of all, that's not a permissible conclusion in the light of EU law. If there were such a rule, it's ruled out by Metal-Gesellschaft. We know that EU law requires the repayment of overpaid tax to include an award of interest on the overpaid tax. And even if that wasn't a requirement, although it is, the learned friend's approach couldn't possibly give us an effective remedy because our claim would be extinguished at an indeterminate time, depending on conclusions in this litigation brought subsequently as to the appropriate utilisation model. And it could potentially be extinguished as early as a few months after the payment of the unlawful tax, and despite the fact that in principle we would have the extended limitation period within which to make the claim. Now that result, in my submission, cannot possibly be consistent with EU law. Secondly, it doesn't fit the facts of this case. I've made the point, ACT was an undifferentiated sum. It's only after the conclusion of the litigation that we know what ACT was utilised and when. And so as a matter of fact, it can't be the case that the debt had been extinguished prior to judgment. There was a cause of action. It was founded on mistake. It's only in the light of the judgment, for the purposes of the calculation of the value of the claim, that we can say which payments of ACT are to be treated as set off against which liability for MCT. That's 35 capital A sub 1. If I needed to, I could alternatively get home under section 35 capital A sub 3 if it was thought that the whole of the debt had been repaid, and we make this point in para 204 sub 2 of our case. But in my submission, section 35A1 will do the job on its own. I don't need 35A3. If I did need 35A3, the analysis would be materially the same. There are proceedings for a debt. Even if particular payments of ACT are seen as giving rise to separate debt, then if the entirety of the debt's been repaid, the court would still have jurisdiction to order interest under section 35A3. And on either analysis, the nature of the claim that's being made remains a mistake-based restitutionary claim. I've made the point already, just as in Prudential, the debts owed to the taxpayer in this case depend on the findings of illegality made in the proceedings in restitution. If I put it another way, and if I take the court back to the example that was given in Prudential at paragraph 72, this is electronic page 3546. In that example of money being paid on the 1st of April, repaid on the 1st of May, it's the Woolwich or mistake claim that gives rise to the debt on day one. All three categories of claim in Prudential, they depend on the ACT being held to be unlawfully exacted or mistakenly paid. And in Prudential, it's precisely because Prudential had brought in-time claims in Woolwich and in mistake, and that the ACT payments were held to be unlawful, that the claimant had a right to interest under EU law. So in my submission, the revenues attempt to isolate the interest claims from the underlying restitutionary claims. It doesn't make sense conceptually, and it's not consistent with the requirements of EU law. So in my submission, I get home on section 35 capital A on this issue. I would also add this further point. If there's a difficulty, and I say there isn't, but if there is a difficulty with the interpretation of section 35 capital A, it would then be necessary to ask the question whether the set-off in section 239 had actually, in fact and in law, operated prior to the proceedings. And given this court's ruling in Prudential that the unlawful ACT is a nullity, my submission is that section 239 would not have operated to trigger an effective set-off in relation to unlawfully levied ACT. The unlawfully levied ACT, as we now know from Prudential, is a nullity. That status of unlawful ACT as a nullity was critical to this court's resolution, both of issue 5A and issue 5B. And if it's a nullity, the purported payment of advanced corporation tax, that can't properly be characterized as advanced corporation tax to which the set-off provided for by section 239 should apply. It's not advanced corporation tax, it's a nullity. It doesn't have any existence as advanced corporation tax. So the unlawful ACT, that's the other side of the coin of the unlawful MCT recognised in Prudential. In Prudential, if you're looking at the lawful ACT, that did answer to the description of advanced corporation tax paid in Section 2391. And the other provisions of Section 2391 did operate in relation to that funded money. So the lawful ACT was available to be carried back, carried forward, and the like. That's why the court rejected my submissions on issue 3 in Prudential. But if, as this court has held, the unlawful ACT is a nullity, there is no basis for the set-off to operate. And as we saw in Prudential, paragraph 110, the unlawful ACT is simply treated as set-off, as a computational exercise that happens after the event. So it's right, of course, for the purpose of computing the claim, that you need to undertake a comparison with what would have happened under a lawful system, and that's what's recognised in Prudential paragraph 110. But it would not be right in my submission, and it would be inconsistent with the nullity analysis for this court to hold that in law the set-off provision actually operated. And on that footing, there can't be any question of there having been any effective set-off prior to proceedings, or any question of the claim for restitution being extinguished prior to proceedings being brought. This is a valuation exercise in which the unlawful ACT is to be treated for the purposes of computing the claim as having been set off against lawful ACT. And that's the explanation of principle that underlies in my submission, paragraph 110, in Prudential. So for the purposes of computing the claim, but only for that purpose, one proceeds on the basis that there was a utilisation of unlawful ACT against lawful MCT. No set-off in reality, there's no difficulty in applying Section 35 capital A. Now, just to be clear, I don't need this analysis to get within Section 35A, but it's an additional route that will get me home in my submission. An alternative possibility is equity. If Section 35 capital A...
Sorry, Mr. Bremner, just before we move on, I just want to make sure that I've understood what you're saying. Am I right in thinking that you're therefore saying that paragraph 78 of Prudential, which is page 3547, proceeds really, I think you would say, on an unexamined false premise that there has been an extinguishment of the restitutionary debt through set-off?
Yes, that's exactly right. I'm very sorry, I look startled. I have my volume turned up very high on my earphones. So
I'm sorry.
Your Lordship asked the question, I fixed that now. My Lord, that's right. So I say that premise needs to be looked at more closely.
Okay.
And I say two things. I say, first of all, that even if that's capable of happening as a matter of principle, the claim can't be extinguished because the Pintada rule can't be applied. But secondly, I make the more general point, and this is relying particularly on paragraph 110, that premise is unfounded, and actually the set-off is merely a backward-looking exercise for the purposes of computing the claim. It is not capable of extinguishing a claim prior to the proceedings being issued.
Yeah, thank you very much.
I was then going to turn to equity. This is on the footing either that Section 35A doesn't apply for the first reason I gave, or secondly because of the nullity analysis that I just advanced. On that footing, in my submission, equity would have to fill the gap and would fill the gap in the common law. We know that EU law required a repayment remedy. We know that the repayment remedy required has to include interest. And we know from Mecklenburg-Gesellschaft that it is not open to the domestic courts to deny the claim simply on the basis that the principal debt had been repaid prior to the issuing of the proceedings. So the question then arises, in those circumstances, what would have to be done? And the answer in my submission lies in equity. It would come to the aid of the common law, and an award of interest on the mistake-based claims could be made by the court in the exercise of its equitable jurisdiction, and the court could proceed by analogy with the rates and practice adopted in relation to Section 35 capital A. And the template for that approach in my submission lies in the features of Lord Walker and Lord Mann in Sempra, which is in Authority 2, tab 15. And the report starts at 3558, but I'm only going in the interest of time just to show you Lord Mann and Lord Walker and how this could be done if we get there. I say we don't need to get there, but if we do, how it could be done. And I can pick up Lord Mann's 36. So let me just check my reference. Yes, I'm so sorry. Electronic page 3627. Where it's the start of his judgment. And then if we can go to paragraph 236. Electronic page 3649. Having differed from the majority on the availability of a common law claim, he aligns himself with Lord Walker and prefers to take up Mr. Rabinovitz, who was appearing for Sempra, his partial invitation to revisit the area of equity. And he acknowledges that that would involve departing from the majority decision in West Deutsche, but then he gives various reasons about the background to that. 237 is Mr. Rabinowitz's submission, letter F, on electronic page 3649. And like Mr. Rabinowitz, we rely on Rogers and Ingham in this context simply as an example of the potential for equity to relieve mistake. Of course, in Rogers and Ingham, the claim failed because it was based on mistake of law. Mistake of law at that time wasn't recognised either at common law or in equity. That, of course, has changed since then, and as Lord Mance's speech shows, that's not a barrier to the relief being given in a claim like this. Paragraph 238, Lord Mance recognises that what would be being done here is recognising an independent equitable claim. That's just under the letter H. 239 is dealing with compound interest. I didn't take up time with that. Subject to the res judicata points, we accept only an entitlement to simple interest. And then paragraph 240, that's Lord Mance's answer. And so he says that in appropriate circumstances, and I would say, well, when a remedy is required by EU law, what more appropriate circumstances could there be? Equity can go further than the common law and provide relief in respect of any actual interest benefit received from any principal sum paid by mistake, even though such principle may be reached before action brought. So that's getting round what might otherwise have been the Pintada rule. And he notes the discretionary nature of the reward. Couldn't really be discretionary in this case because, of course, it's a requirement of EU law. And I should just also say one other thing. Lord Mance puts the point in terms of actual benefit. That doesn't give me any difficulty in this case because the revenues argument on actual benefit has failed on the fact. That was issue 23 in FII High Court 1, paragraph 424. And the reference for that, we don't need to turn to it, is electronic page 1400. So there's no distinction in this case between the conventional rate and the rate produced by actual benefit, which exercised Lord Mance in Sempra. That's all I need from Lord Mance. You can see the models for what could be done. Lord Walker, I only need 2 paragraphs, I think, from Lord Walker's judgment. The first of those is paragraph 184, which is page 3626. And that is where Lord Walker confesses between C and D that his own inclination would be to take the step that the House of Lords drew back from taking in West Deutsche, and that was to extend the equitable jurisdiction to award compound interest and putting compound interest on one side. And then he goes through 185, refers to Lord Goss and Lord Wolfe, and then there's further detail about those judgments. 187 is his apprehension about the notion that compound interest should be available as a right. Well, that doesn't obviously arise here in relation to compound interest. And then paragraph 188, his analysis, that led to the same result as that which had been favoured by Lord Hope and Lord Nichols. Now, in their case and reply, the revenue say this approach wasn't taken by the majority. Well, that's not an answer. The majority didn't get to equity because they thought the remedy was available as a right as a matter of common law. If one looks at the speeches of Lord Nichols and Lord Hope, this common law route hadn't been available. There can scarcely be any doubt, given their observations about the justice of the situation, that they would have found relief to be available in equity. And you can see that those remarks on justice in particular, we don't need to go to them, but it's Lord Hope at paragraph 33, electronic page 3583, para 41, page 3585, and Lord Nichols at para 52, page 3589. And then the revenue's second line of defence in relation to this is to assert that this route is not permissible because it's been ruled out by prudentials. What they seem to be saying is that because there's no common law restitutionary claim, there can't be any equitable award either. That's simply wrong. What would be happening here is that equity would be coming to the aid of the claimant insofar as repayment of debt is held to have taken place prior to the issuing of the proceedings, and therefore, against the submissions I've been developing, removing an unjust enrichment claim and barring the application of Section 35A. And looking at equity, equity doesn't depend on showing that there is an enrichment at the expense of the claimant. That was the point upon which the unjust enrichment claim for the Sempra period in Prudential was held to be defective. So we know that a remedy for Category A claims is required by EU law, and if there's a gap, there is no difficulty in my submission in equity filling that gap. And just so there's no doubt about it, the basis of the claim in that scenario would remain a mistake-based claim. It's the overpayment of tax by mistake that grounds the conclusion that there's to be any relief at all. And you can see that, as it happens, from the result in Sempra itself. Lord Walker concurred in the order that compound interest was payable on all of the claims. And you can see, if you still have electronic page 3628, in paragraph 190 of the speech of Lord Mans, the claims in Sempra, they included 3 claims that had been made more than 6 years prior to the proceedings being issued. You see right at the bottom of 3628, the writ issued 6 March 96. And there had been ACT payments made in 1981, 1985, and 1989, if you look at the third column in the table. So there can be no serious doubt in my submission that the extended limitation period would apply in relation to equitable relief of that nature. And that fits with principle because it's the overpayment of tax by mistake that triggers the EU law right to repayment in the first place in this case. And if it really came to it, in the last resort, I suppose the court would have to mould the common law requirement of at the expense of. If it's really the case that the existing claims weren't within Section 35A, really not the case that an award couldn't be made in equity, there would still need to be a domestic law remedy. I say we never get to that stage, but at that point in the analysis, the option remaining would have to be to say that EU law precluded the application of the restrictive analysis of the common law unjust enrichment cause of action that's just been recognised in Prudential, I suppose. But I say we never get there. I should just say a brief word about the FID.
You are rather assuming that the domestic remedy would have to be provided by the courts. And the alternative is that it could be provided by Parliament.
Well, my lord, it has to be provided by the courts because there was no statutory remedy, and there has to be a remedy in domestic law. There was no remedy until Finance Act 2019, enacted in February 2019.
But the obligation, I mean, if we're talking about a conforming interpretation, or indeed about inventing remedies on common law or in equity, there's no the EU obligation isn't an unlimited one. It operates within the constitutional boundaries of what courts do.
Well, that's right. What I say is, first of all, that we're dealing with a procedural bar. That was why I showed you the extract from the Advocate General in Pintar. It's a procedural bar. That bar can't be permitted. And as soon as I have that conclusion, the analysis is very straightforward, because there is no difficulty in applying Section 35A, because the only reason 35A is potentially a problem to me is because of the judicial glove on Section 35A in Pintada. Pintada, IM properties, I don't need to go into the detail of that. That simply can't be applied. Once the bar can't be applied, it falls. The bar falls generally. And so at that point, all the remedies that would be available, absent the bar, they are available, and the claimant can elect between them. So that is very straightforward. And I'm not asking you to invent any remedy at all at that stage. I'm simply saying the bar falls. That's the end of it, and I get home on 35A. When it comes to equity, I'm simply drawing an analogy with other cases where equity has provided for relief, and there is no constitutional difficulty or difficulty of constitutional propriety in what I'm asking the court to do. It's not an answer in my submission to say, well, in Prudential, it might have meant that the UK law is defective and Parliament will have to legislate. That's not in my submission a tenable reading of what was decided in Prudential at paragraph 78. A remedy is recognised that exists in domestic law, and there was no legislation in domestic law that gave effect to that remedy. And you have to look at the causes of action that were being deployed by the claimant to give effect to their rights at that particular time. So if you look at these claimants, they bring the causes of action that give effect to the San Giorgio right, and we know from FII Supreme Court 1 in particular, the speech of my Lord Reid, that it's the mistake-based claim and the Woolwich claim that give effect to the San Giorgio right, both of them. Part of the San Giorgio right is the right to interest. And what we're discussing now is, well, is there a bar that prevents the interest award that is otherwise inevitable? Prudential tells in paragraph 77 in relation to the other categories of claim. And I say, no, there's no such bar. The bar can't be applied, and we know that from her. And that reflects the later jurisprudence, and particularly the developed conception of interest being an integral part of the restitutionary right, indeed as recognised both by the Court of Justice in Littlewood, in the passage we cite in our written case, and also by this court in Littlewood Supreme Court in the paragraph that I referred you to earlier. So there's no such difficulty in my respectful submission. And I'll come on to Section 85, because there's also no question of Section 85 being able retrospectively to limit the domestic remedies that are available. We had this right in domestic law. We must have had it to give effect to our EU law claim throughout the period, going back to 1973, assuming that we can get within the extended limitation period. We had that right clearly recognised in July 2018 in Prudential. It can't be cut down by later legislation, which later legislation in any event is not exclusive. But I'll come on to Section 85 in a minute.
Mr. Bremer,
Lord Reid, yes, of course.
I hope you've still got paragraph 190 of SEMPRA open. It's page 3628.
I'm very sorry, Luke, because I've only got every second word of that.
Oh dear. I hope you've still got page 3628
Yes, I do.
open. Paragraph 190 of SEMPRA. The whole of a central feature of your submissions this morning in relation to the set-off of unlawful ACT against lawful MCT, which I think is what paragraph 190 is all about, is that you can't put a date on the time when the set-off takes effect earlier than the process of computation in the proceedings. It appears that it's treated as plain or obvious that you can put a date on it, in the sense that the whole of paragraph 190 is structured around a concept that even if it's treated as kind of set off because the ACT, unlawful ACT, is a nullity, it still happens at a treated as date.
Let me be clear about the point that I'm making. It's right that at that time in Sempra and Hearst was the same, that there was an assumption, effectively, that set up equal payment. That assumption now needs to be revisited in light of the insight that this court's given on nullity and prudential. Of course, this is right, that for the purposes of computation, you can look back and you can allocate a date for when the setup is to be treated as having happened. I accept that, and that's done in the computations in order to produce the ultimate figures. So I'm not saying you can't give us a date. What I'm saying is that at the time that the proceedings were commenced, you cannot say that the claim has been extinguished. That's the critical step in my argument. And in the light of the requirements of EU law, you also cannot say when you're valuing the claim that you need, when it comes to what my Lord Briggs said, the treated as exercise, you can't say that we have to treat the claim as having disappeared many, many years in the past, because that would fall foul of effectiveness, because it would have been extinguished at an indeterminate time and many, many years before the limitation period would have expired. That, in my respectful submission, wouldn't be a permissible analysis.
Thank you.
Before I turn to section 85, I was just going to say a brief word about the FID claims. Conceptually, the answer in my submission is the same as for the ACT claims, which is what I've been concentrating on. There is one factual feature that is different about the FID claims. It doesn't affect the answer of principle. The factual feature that is different is that in the case of FID claims, the ACT was repaid. So the point that I was making about there being a running account and the ACT never being utilised, which applies in relation to the non-FID ACT claims, that doesn't apply here. For the FID claims, there is a payment of money as tax, unduly levied and paid by mistake, and it is subsequently repaid. So there was a real repayment of FID ACT as opposed to a deemed setup. But there is no difference in my submission of principle or of outcome, because all my submissions of principle apply equally to FID. Prudential, it acknowledged the existence of a claim, paragraphs 78 and 110, and I say such a claim couldn't have been extinguished on repayment without breaching the principle of effectiveness, and that's given metal gesellschaft, that's given that the limitation period had not expired, and the policy of the Limitation Act being to protect claims in mistake from expiring before the mistake could have been discovered. And as it happens, and just for completeness, the claimant in Prudential, it had paid a FID, and nowhere does Prudential Supreme Court imply that that should have been treated differently. So, in my submission, Section 35A applies, or if it doesn't, an alternative can be found. And Section 85, Finance Act 2019, in my respectful submission, is just a red herring. I say that it is irrelevant to this case. First of all, it's clear on the face of Section 86.2 that the remedy that's being provided is non-exclusive. It might be worth having this in front of us as we do this. It's electronic page 3053. So 86.2, which is over the page on 3055, tells you in terms that the remedy is non-exclusive.
Mr. Bremner, I'm so sorry to interrupt.
Yes,
just before we get into the meat of your submissions, can you help us at all with why the various dates have been chosen within Section 85? I mean, I appreciate we'll need to ask Mr. Hewitt this as well. But in subsection 1, why the date of the 12th of December 2012? In subsection 2A, why the date of the 1st of January 1996? And in subsection 4, why are we given appropriate rates starting on the 1st of October 1993? Can you help with any of that?
Well, I can't really, I'm afraid, my lord. The 1993 point is interesting because learn from Mr. Hewitt. He says you can't go back before 96 in any event. And it so happens for these claimants, if the revenue is right, that would be right because of the date when the claim form was issued. I can't help on why the dates have been chosen.
All right.
I mean, my submission is that the dates rather illustrate the inappropriate nature of concluding, or the inappropriate result that would follow if the court were to conclude that Section 85 removed the other domestic claims without submitted votes. So this is all arbitrary and after the event. And what seems to have happened is the draftsman has chosen these dates, or 12th of December 2012, that's good enough. And they've gone back a particular period of time, 6 years obviously matches the Woolwich cause of action. But none of this, as we'll see, actually give an effective remedy, certainly not to the claimants in this case. And you can see why this problem to arrive after the 12th of December 2012 or in respect of a claim issued after the 12th of December 2012, you couldn't get the Section 85 remedy anyway. So we really are through the looking glass in an Alice in Wonderland world, where in February 2019, on the revenues case, a remedy is just being made up and then is reaching back to prior events. And that, as you'll see, can't possibly be permissible. But I'm afraid, in terms of the reason principles for dates, I can't identify one. I think it shows the arbitrary nature of what's going on.
Thank you.
I'd make the point that it's settled law that Section 85 and 86, they can't take away existing rights that the claimant enjoyed. And we know from Prudential, Paris 78 and 110, that the claimants have a claim for interest on the Category A amount. And that claim necessarily arose independently of Section 85. And that's simply because Section 85, it didn't exist. And it wasn't even in anybody's contemplation when the judgment was given in Prudential on the 25th of July 2018. And Royal Assent was the 12th of February 20. Oh, I'm sorry, Lord Phil.
Just on that, I mean, Section 35A of the Senior Courts Act it doesn't give you a crystallised right to any particular rate of interest, does it? Until you get to the end, and then the court exercises at the end of the proceedings its discretion to award a rate. But I just wondered to what extent there is a, if you like, crystallised remedy under Section 35A until you get to the court actually carrying out its discretionary exercise at the end of the proceedings.
So the remedy, you would still have to give an adequate indemnity in terms of little. It isn't an issue in this case because the relevant rates are agreed. That's in the Statement of Agreed Facts, paragraph 18. And you'll see that at electronic page 2860. Let me just show you that. Actually, that's set out. Yes, that's set out the relevant rates, and then I can tie that together by showing you the judgment in SIR High Court 2, which is electronic page 1407.
But just on the relevant rates,
yeah.
As I understand it, those are indicative of the way the court would usually exercise its discretion under Section 35A. It didn't seem to me to change the nature of the exercise that the court carries out, that it is an exercise of a discretion at the end of the proceedings under Section 35A, does it?
Just so I understood your question, your lordship's looking at 35 capital A.
Yes.
Not at 85. So it's an award that the court made, and as a starting point, it's made in the court's discretion because it says may, and there are no rates specified. But there is, however,
perhaps we should just call it. Perhaps we could make sure everyone has it. It's page 3230 in the electronic bundle. If you're making points on it.
Yes, I'm sorry. Yes, on 35 capital A, the starting point in domestic law is that that the award is discretionary, 35A1. But we know that this is a substantive right under EU law. So the discretion would have to be exercised in the claimant's favour. Wouldn't be open to a court to say, well, we're going to give you no remedy for interest, nor indeed would it be open for the court to make an award that didn't represent an adequate indemnity. We know that from Littlewood's Supreme Court. We also know what the practice is on making awards under Section 35A.
Could I just, sorry to interrupt you, could I just ask a question at that point? I appreciate you say Section 85 is a red herring, but if by the time the court has to decide whether to make an award under Section 35A, it can see that there is a power to award interest under another provision, Section 85, and at a rate that satisfies the EU law right, could it not award that rate of interest and then say, well, there's nothing additional that we the court need to do in exercise of our discretion under Section 35A?
Can I deal with that, Lord, in a number of steps? First of all, that wouldn't work for the prior periods. So 85 wouldn't give you any guide for the earlier periods at all. You couldn't use 85 in that way.
And when you say the prior periods, you're meaning prior to 1996. Is that what you mean by the prior period?
Prior to 96, there was no remedy,
okay.
and certainly prior to 1993, because there's no rate specified, because these claims go back to 1973. So that doesn't work conceptually. That's the first point. So I have to have a remedy consistent with EU law for those earlier periods. My second point is that it cannot be right. What we are looking at, and we know this from FII Supreme Court 1 and FII ECJ 3, in that context, it hadn't been definitively established that mistake claims were available when the retrospective limitation period came in. The Court of Justice made absolutely clear at the end of its judgment in FII and ECJ 3 that didn't prevent the protection of EU law. And so what we have in my submission is a situation where we know what the practice is under 35 capital A, and it wouldn't be right after those proceedings have been brought for Section 85 to be used through the back door to change what that entitlement would be. That's how I would answer my Lord Sales' question. It can't play on any view for the period prior to 1996, alternatively prior to 1993, and then secondly, it shouldn't be applied because of the retroactive nature of the exercise in relation to concurrent periods. There's also a separate point as to whether the Section 85 rate give an effective remedy at all, but perhaps I can, for the periods that they are applicable to, but perhaps I can come on to that separately because that's a separate point. But I hope that answers my Lord Sales' question.
Yes, thank you. Thank you very much.
So are you saying that we have to decline to apply Section 85?
Well, Section 85 tells us that if we have another relevant remedy, then we don't get the Section 85A order. That's Section 86.3. So not only is Section 85 non-exclusive, this is 3055, not only is it non-exclusive, you can't double up. And in this case, the interest rates were agreed at the trial. So this is the point I was just about to show the court before I answered Lord Sales' question.
Yes, what I'm wondering is, if your submissions are right, can Section 85 ever be applied?
It depends what the claimant is seeking. We're seeking an award under 35A. It would be open to us, if we elected to do so, to say we would like to go under Section 85. In that case, there would be no award under 35A, and the award would be made under Section 85, non-exclusive and no doubling up. But the submission that I'm making to the court is that we should have the interest award under Section 35A. And if I'm right about that, then we take the consequence of that. We take the consequence of that and get the award under 35A, and then because of Section 86, subsection 3, little a, on page 3055, I can't also ask the court for Section 85 interest. It's not a question of Section 85 never having any other application. There's also, in addition to that,
but it can only apply where a taxpayer opts to have it applied to him.
No, because there's also a more fundamental conceptual point that Section 85 would apply if the claim was issued more than 6 years after the date from which either the tax had been paid, or beyond 6 years after the date upon which the taxpayer could, with reasonable diligence, have discovered his mistake. So in those situations, you would need the Section 85 remedy. Because all that is condition, so the only condition in Section 85.1, if you look at 305.3, is that there is a starting of proceedings on any date before 12 December 2012. And my learned friend, Mr. Hewitt, sought to explain that it leads to a certain number of oddities. But Section 85 seems to assume that regardless of whether those proceedings were brought within the time limit in the Limitation Act, the claimant would still get his order under Section 85. So Section 85 would play in the event that a claim is issued beyond 6 years after the date upon which the claimant could, with reasonable diligence, have discovered his mistake. So common law claim at that point time barred, but 85.1 little a, we did start proceedings before 12 December 2012. The proceedings include a claim, and the claim hasn't been settled, discontinued, or finally determined, and then such three persons entitled to an order. So I don't accept, my lord, that the submission that I made would mean that Section 85 either was rendered useless, or that it would simply be a matter at the option of the taxpayer. That's not right. It does have a role to play. It just plays in a different way to the manner in which learned friend Mr. Hewitt described it on Monday. Can I just go back to the question of the rates of interest, because this is important from a procedural point of view. If you go to paragraph 449 in FII High Court 2, this is electronic page 1407 at the bottom, that picks up on what I remembered slightly too late was the rather detailed and tedious discussion of interest rates in the Statement of Agreed Facts, which was the first document that I showed you. And the detail of those interest rates didn't actually matter at trial, because you see, as the judge records, and there was a claimant's case, 6 monthly rest, and then for their part, the revenue rely on a table of annualized rates, and that had been drawn from Littlewood. But then, this is important, since the end of the present hearing, the parties have fortunately been able to agree that both approaches yield the same result. And so there was agreement as to what the rate should be, and that was then reflected in the judge's orders. For the Section 35A rate, they actually were agreed. And so if my own friend were to go down the route of saying, well, okay, Section 35A might apply, but I would ask the court in its discretion to apply a lower rate, he can't do that now because he's conceded what the rates under Section 35 could be, and we're long past the stage in my submission, even given all the concessions that have been withdrawn in this litigation, for that to happen. So in my submission, in relation to Section 85, what it can't do is, with retroactive effect, cut down the right that was recognised in Prudential at paragraph 78. And that's particularly so in the light of what the CJU said on the third reference, and particularly paragraphs 50 to 52, which are electronic page 1690 for your note. And the point I draw from that, the point I made in answer to your sales, that it didn't matter in that context that the availability of the mistake claims had not been definitively established at the time that the retroactive change was made. And actually, in our case, Prudential had recognised the entitlement. We had brought the claims as long ago as 2003. And I do say that if Section 85 were to cut down the right recognised in Prudential, that would be a plain breach of the principle of legal certainty and of legitimate expectation. And there's no question, if we're in the realm of conforming interpretation, there's no question of the conforming interpretation obligation somehow being switched off. The right that was recognised in Prudential is part of domestic law. The court didn't give it a name, but it absolutely is part of domestic law. And having been recognised, it can't be removed as a consequence of Section 85. So the learned friend's approach of saying, well, we only have to look at Section 85 and we need to go no further, is simply and plainly wrong. You have to work out what remedies in domestic law gave effect to the right to interest. That involves looking at the position pre-Section 85. Then you have to ask, what is the effect of Section 85 on that provision, on that position, I'm sorry. And I say, in addition to that Section 85, in any event, is incapable of giving an effective remedy. I've touched on some of these points already, but just to make sure I've made them in this context. In opening, all the learned friend managed to demonstrate is that for periods prior to 96, no claimant would have any remedy under Section 85. Now, query whether you might hypothesize some circumstance where you could go back to 1993, because the table of rates goes back that far. That doesn't take things anywhere. Look at BAT. It issued its claim in 2003. And there's no ability for it in 2019 to make a claim that reaches back to 1993. And so it either can't go back beyond or before 1996, or it can't go back before 1993. The consequence on the revenues case is there is no remedy at all in domestic law. And that can't be right. And it's not an answer to say, well, maybe a remedy might time bar. Remedy bars the action being brought. It doesn't extinguish the right. So it can't be said in my submission that there was never any remedy in law for periods prior to 93. That's obviously impermissible. We know that in particular from the Court of Justice's judgment in Irony. And just for your note, it's paragraphs 26 to 29 in that judgment at page 6249. We know that because what we had there was a national rule that failed to provide for interest from the date of overpayment. Instead, it started it at a later date, and that gap breached EU law. Well, on the revenues case, in these proceedings, it's now being said there was never any remedy at all prior to 1996, alternatively 1993. That can't possibly be right, given the recognition that interest is part of the San Giorgio relief that's required. But it doesn't cover all the relevant...
Lord Sales has a question for you.
Yeah, sorry, Mr. Brenner, before you move on from that, I think I'm understanding your submissions on Section 35A that you don't need to press for a special leasing conforming interpretation of Section 35A to bring yourself within it. I think I've understood that to be your primary submission.
Yes.
But if you did, might it be said that, well, for the periods of time where Section 85 doesn't apply, doesn't provide a remedy, that's just to say that one needs to, in those circumstances and for those periods, to apply a conforming interpretation of Section 35A, which you say, if necessary, could be done. But when one is in a period for which there is another provision which provides sufficient remedy in respect of interest as required under EU law, that pressure for a conforming interpretation of Section 35A disappears, so that if this be right as a matter of analysis, one is left then with Section 85, if that is a sufficient and appropriate remedy in respect of interest for the period when it applies.
No, my lord, because the consequence on that approach would be that there had previously, prior to February 2019 in the enactment of Section 85, there would have been a general remedy achieved on this hypothesis. And your lordship's got my point that I say I don't need to get to conforming interpretation, but let's work with the hypothesis and suppose that I do for the moment. prior to February 2019, there needed to be this conforming interpretation so that Section 35 capital A could respond to the mistake claim, and so the procedural bar didn't apply, and so you can make the award of interest pursuant to Section 35A in response to the mistake claim. The consequence of that is that right in the claimant to seek interest pursuant to Section 35A to give full effect to the mistake claim, so that extra element, that is part of domestic law. And it's part of domestic law prior to February 2019. And it cannot, in my submission, properly be said that that right can be taken away by the enactment of legislation in 2019, February 2019, because that would be to remove retroactively, without any transitional provisions, the right that already existed. And that's why I say that the proposition which Mona Friend acceded to on Monday in answer to a question from the Lord Sales, that the conforming interpretation obligation could be switched off from February 2019 onwards in relation to periods covered by Section 85, that is wrong, because it breaches the principle of legal certainty and legitimate expectation. It takes away something that the claimants previously had in domestic law. And just to add to that, precisely because Section 85 is non-exclusive because of Section 86(2), it cannot be said in my submission that the conforming interpretation would need to be modified. It's simply that there already is a remedy on this hypothesis as a result of the conforming interpretation of Section 35, capital A. So I hope that answers my Lord Silver's question.
Thank you very much.
I was going to make a couple of further points on Section 85. I can probably do the first one before. Actually, I see it's 1 o'clock. You may prefer to stop rather than me embark on another point before the short adjournment.
Yes, I rather think so. We'll adjourn now and resume at 2 o'clock. Thank you.
Very grateful.